Not all visa denials are the same. Some mean try again with stronger evidence, some mean we need more time, and some, but very rare, mean a serious legal problem. Today, you will finally understand the real difference between 214B, 221G, and 212A visa refusals, and what each one means for your future. By the end of this video, you will know exactly which type of a denial you received from the embassy, and what smart action you should take next based on it. Now let's dive straight into it. 214B, let's name it you didn't convince us. This is the most common denial for B1, B2 tourist visas around the world. It means the officer believes you didn't prove one or more of these things we previously talked about in previous videos. You have strong ties to your home country, your trip is a truly temporary trip, and you can afford the trip without illegal work. This is important to understand. A 214B denial is not permanent, means it is not a forever denial. It simply means your application, your documents, or even your interview didn't create enough trust at the moment, and you can reapply once you can fix and strengthen your case. Now let's move to the 221G, and let's name it we need more information. Think of 221G like hitting a pause on your visa decision, not a full no. This is when you receive an administrative processing on your visa application. Actually, this happens when the officer wants additional documents or your case needs extra administrative processing like security checks or some verifications, or even some more information was missing or unclear. You'll usually receive a form listing what they need. So until you prove it or until the embassy finishes their checks, your visa cannot be issued. So the key lesson here is that 221G doesn't automatically mean visa refusal, but it can delay your visa decision for a long time. And sometimes, after extra review, a refusal can still happen if problems are found. And now let's finally explore 212A. You are eligible under the US law. This is the most serious category. 212A covers many different legal issues, such as past immigration violations like overstaying your US visa, or criminal records, or even misrepresentation or fraud on your immigration application, and or of course any health or security related concerns. Some 212A problems are permanent unless you qualify for a waiver, and that's why there is an I-212 waiver application that can be submitted with the United States Citizenship and Immigration Services, the USCIS. If you receive a 212A denial, you must understand which exact subsection applies to you, because each one has different consequences. For example, 212A6CI. This is the misrepresentation. That means very serious, and this is of course may require a special waiver. However, I want you to take into consideration that some of these problems are fixable depending on your situation. Think of these codes like traffic lights. 214B, this is the yellow light. You need a stronger evidence. 221G, flashing yellow. Wait and respond carefully. 212A, red light, serious problem. Professional help may be needed if you receive a 212A. However, and always, you must consult with an experienced immigration attorney with your specific situation and circumstances. Here is where many applicants go wrong. They reapply immediately after a 212B denial without fixing the root cause, or they ignore the 221G document requests and get automatically denied, or even they misunderstand the 212A and assume a simple reapplication will fix the issue, but in fact it won't. You need to have a strategy, not just a speed. In the next section, we will go even deeper, showing you exactly how to rebuild and repair your visa application.